All right. Still more elements go over when discussing the features of CBAM. So, what is an importer of any of the products that is currently covered by a CBAM? So steel, aluminium, and so on. What is such an importer supposed to do? Well, he has to declare the total imports of covered products and the embedded emissions in them. That's the declaration that he has to make. And this is an obligation that currently is already in force. When, as from the beginning of next year, these importers will have to pay the carbon tax. And in order to pay that tax, this is the way in which it's organized, they have to purchase CBAM certificates. Now, the price of these certificates, and this is why CBAM is a carbon price equalization system, the price of these certificates equals the weekly average of price, the weekly average price of emissions allowances under the European emission trading system. So it's the price that European producers pay for emissions in Europe. The price of the certificates is the weekly average price that European producers pay for emissions in Europe. The price will be adjusted for free allowances that are still given to domestic producers. So the importers buy these CBAM certificates, and they will have to surrender these certificates to give them over for the declared imports and the embedded emissions at the end of every year. Unlike under the European emission trading system, there is no market for these CBAM certificates. You can, under certain conditions, you can sell them back to the European Commission, but you can't trade them. And that's a big difference with what domestic producers can do, because they will have their certificates, and they can trade these certificates. There are exemptions from CBAM, meaning that there are countries whose imports are not subjected to CBAM carbon taxes. Which are these countries? Well, there are the countries that actually apply the European emission trading system, and these are Iceland, Liechtenstein, and Norway, or countries such as Switzerland that have their own emission trading system that is fully linked with the European system. And the UK is currently thinking of something similar to Switzerland, to have their own emission trading system, but one that is fully linked with the European emission trading system. Imports from these countries are exempted from carbon taxes. There are, and I mention this because there has been quite some discussion about this, there are no exemptions for imports from least developed countries. I've heard often an argument made for that. But for me, it's quite obvious why there are no exemptions on that. Because if there were exceptions, you would see all the steel companies moving to these developed countries. It's an exaggeration because, of course, you have to have infrastructure, you have to have a workforce that is capable, and so on. But you would see that over time. You would definitely see that, and that cannot be the idea, because then actually, so no exemptions for imports from these developed countries. There is also, and that is in addition, of course, of the exemptions. There is also something like CBAM discounts. And these are much more important to all other countries, because the list of countries that are exempted from the system will remain very limited. But the possibility to get a CBAM discounts is open to many, many more countries. You get a CBAM discount for imports from countries that themselves apply carbon pricing. So if you domestically you put a price on carbon emissions, then you get a discount in the sense that you can, whatever you have already taxed domestically will be deducted from what you owe the European Union, will be deducted from your European CBAM carbon tax. So, I think that is going to move, and that's the hope of the European Union. It's going to move many countries towards introducing carbon taxes. Because whatever you do domestically already, you can. China is here an example. China is very seriously working on its own carbon tax system. And yeah, the extent to which then carbon is taxed domestically will be taken into account in the calculation of the carbon tax that you need to pay on entry into the European Union. And I understand that India may feel pushed to go the same direction, to also introduce a carbon tax system. Because if you don't, you will lose out against those countries that do introduce such a system. Right.
Excuse me.
Now, final. Yes, of course.
Sorry. What if they use different default values? If China uses different values for calculation, calculation of the carbon tax, and the EU uses different.
Well, I'll come to that in a later comment. And since you asked the question, I'll address it now. Now, this is the big problem. Yeah? This is the big problem because there's no unified, agreed way of calculating the carbon embedded in a product. And of course, depending on how much carbon is embedded in a product, a tax will be imposed. This is a huge problem, and there are currently negotiations ongoing, even within the context of the WTO, but also outside the WTO, on how can you possibly come to an agreement or at least an understanding of how one has to calculate how much carbon is embedded. Because that will then determine the pricing, that the carbon pricing. And I think Professor Sharma will have additional comments on this. And I'll say something about it, but not much, when I come to Article 20 and the chapeau of Article 20. The European Union will, when it has troubles of accepting the way in which a country calculates the embedded carbon will fall back on default values. And these default values are very unpleasant for the. So, but there are also developing countries that just don't know and don't have the means to calculate to give data on the carbon that is contained, embedded in exported products. Right, last point, almost last point on the features. The CBAM revenue, where does the CBAM revenue go to? And there has been a lot of discussion also in the European Parliament that CBAM revenue should then be reserved to help developing countries to address the climate crisis, to help them to lower their carbon emissions. No. Yeah. The CBAM revenue goes into the general EU budget. To the extent that it will then be used in the context of fighting climate crisis, it will be more used, not exclusively, but it will be more used to help regions in Europe that are particularly hit by the CBAM regime, and there are those, to help the industries in these regions to adapt. Some of the money will undoubtedly go to developing countries, but the initial idea of some was to reserve all the CBAM revenue for assisting developing countries to reduce their carbon emissions. The stated objectives, and allow me to say that, or allow me to remind you of the stated objectives of at least part of the IRA. There we had explicitly the statement that to support the domestic industry. Yeah? So watch out for this. The stated objective of CBAM, well, to prevent the risk of carbon leakage. Of course, that has a dimension of protecting the domestic industry, but it's not explicitly focusing on the protection of the domestic industry. So to prevent the risk of carbon leakage, to reduce global carbon emissions and support the goals of the Paris Agreement, reduce global carbon emissions. And the idea behind this, as I discussed, is to almost force other WTO members to become more carbon emission reduction ambitious, or to become more climate policy ambitious. Because if you don't put a price on carbon, we will do it for you, and we will do it on your imports. And last objective, to allow for a phase out of the free allowances that were there under the European emission trading system. That brings me to the question whether all this is WTO consistent. Is CBAM WTO consistent? Well, I think this is one of the things about which most was written over the last 2-3 years. An enormous amount of literature, economic literature, legal literature, international relations literature, even on the consistency. The debate actually starts with the nature of CBAM. The nature of CBAM measures, what are they? Are there border measures or are there internal measures? Are they regulatory measures or tax measures? Now, we've been talking about a border tax, carbon tax. But if you listen to a European Union official, they will say that this is a regulatory measure. It's a regulatory measure. And it's maybe a border measure, but it's a regulatory measure. And the reason why they don't want to say that it is a tax measure is because the competence of the European Union in the field of not of border taxes, but in the field of internal taxes is still more restricted. So they're very much afraid of challenge by the European Court of Justice by one of the member states of the European Union that see that and actually, so that's why they insist that it is. But is it really? Is this not I'm not going into that discussion. But if it were any of those, there's a possible inconsistency with, obviously, Article 2.1 of the TBT agreement. If it's a border tax in the form of then it would be a prohibition of, to fall under the prohibition of other duties and charges, under Article 2.1 of the GATT. If it were internal measure regulation, internal regulation, internal measure taxation, it would fall under Article 3.2, which would impose a national treatment obligation regarding internal taxation. If it were an internal measure regulation, it would fall under Article 3.4. If it were a border measure regulation, it would fall under Article 11. And it would be prohibited, 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 prohibited. But I don't know. Yeah. I mean, there are arguments, if you consult the literature, there are arguments for all of this, the classification. But it's definitely inconsistent with Article 1. Whatever the measure is, whatever feature it takes, it's going to be inconsistent with Article 1. So we have an inconsistency. That brings us to the question whether it can be justified.
In the regulatory measure, be external. So is there an example of a regulatory method that has external consequences?
Well, that's yet another question, but when I talk about a regulation that is external, I would link it to a regulation that is applied at the border. Yeah?
Okay.
And a regulation applied at the border, we usually don't think in those terms, but that would be a quantitative restriction. Yeah? Now, your question brings to the table something else. A regulatory measure, an internal measure that has extraterritorial application, that would still be an internal measure. And then the question is whether these external consequences are justifiable. Because that's what the country would complain about.
If then they claim it to be a regulation, then they will have to claim it as a decision or a border.
Yeah.
Because a regulation has to be strictly internal.
Yeah. Yeah, no, you can build up a reasoning. But we don't care. Yeah? Because we have a violation. And I want to come to the justifications. Yeah? I want to come to the justifications. Justification under Article 20. The first question that would arise, and that sort of links up with what you said, is there a jurisdictional limitation on the use of Article 20? Because what is CBAM doing? CBAM is addressing carbon emissions outside the jurisdiction of the European Union. Can you invoke Article 20 as a justification for a measure that actually tries to protect values and interests outside its own jurisdiction? Well, I think yes, because there is a sufficient nexus between CBAM, the measure at issue, and the Earth's climate, the climate crisis. There's a sufficient nexus, yeah? And that would suffice. Furthermore, to the extent that, as we will see later, you would invoke Article 20A, public models, okay, there the extraterritoriality doesn't play, because there you would argue that the measure is justified because it is necessary to address public moral concerns of European citizens. Yes, of what happens elsewhere, but it is the public moral concern of the European citizen. So there the extraterritoriality problem goes away. Yeah? But I think you don't even have to go that far. I think there's a sufficient nexus. Where does that idea of a sufficient nexus come from? It comes from the US shrimp case. And the appellate body in US shrimp did not have to address the extraterritorial application problem head on, because these turtles were swimming in and out the territorial waters of the United States. So, yeah, they were also territorial at some points. So they didn't need to answer that question, but they did nevertheless say that what you would need is a sufficient nexus between the measure that is otherwise GATT inconsistent and the environmental or other objective that is being pursued. There's one case in which a panel, a case involving India, actually, the EU trade preferences case.
Tariff preference.
Sorry?
EU tariff preference.
That's it. EU tariff preferences. Thank you very much. EU tariff preferences case. In that case, the European Union tried to justify one of the measures at issue by saying that they needed a measure to protect public health outside its territory. The panel said, no, you can't do that. So there are, at least according to that case law, by panels, that never went to appeal. There may be extraterritorial limitations on the invocation of Article 20, but I don't think we should worry about that in this context, because there's a sufficient nexus between the measure and the objective pursuit. Yeah, trying to express that in one sentence. Carbon emissions anywhere affect everyone, everywhere. Yeah.
Explicitly, Article 20 does not restrict any exception on the basis of extraterritorial.
No, no, not explicitly. No, no. I can't read anything in Article 20 that really answers the question of whether there is a jurisdictional limitation on the application of Article 20. But have to reason about it. The justification is to protect certain societal values, and these societal values are the societal values of the society that adopts the measure. Yeah? At least that's the way in which it has always been understood. And I think in terms of recognizing the sovereignty of other WTO members, it's the way in which you have to read it. Because if you could read it as justifying the protection of societal values anywhere in the world, and this would be a brief for very activists. No, so, but you're right to point out, if you read Article 20, that you don't find that limitation in the wording itself. Question nevertheless arises. and for the reason that I explained. All right. So we can apply Article 20. Question is, which provision of Article 20 are we going to apply? A, B, D, or G? You say G. B. Oh. Does everybody agree with going first to B? You changed your mind? Did that no, change your mind? Okay. Right. Okay. Anybody disagreeing with B? Anybody has another preference? A, B, D, G, B. Happy to see you disagree with her. Why would you go to G before you go to B? Now, a good lawyer would argue both, yeah? But you would argue one first and then the other. Exactly. Yeah, exactly. Because of the test that you will have to meet. Yeah? And the test under G is a related to test, which is a much softer test than yeah. So it's the necessity requirement versus the relating requirement, which will make you choose between these. And A, B, and D require that the measure is necessary. G only requires that the measure relates to, plus the last part of the sentence, but we'll come to that. Now, if we go for 20G, the first question that we have to ask is, what is the exhaustible natural resource? Now, we've already answered that question a number of times. The exhaustible natural resource would be a stable climate, livable climate, or perhaps the climate. And I think we discussed this yesterday also. Is that far-fetched? Not really, because in the very, very beginning of the appellate body jurisprudence, we have the United States gasoline case, where clean air was accepted as a. There is a difference between, and certainly if you take the context of that case, between clean air and carbon emissions affecting the global climate. There is a difference, but I think if clean air is already an exhaustible natural resource, then probably the climate is too. So a stable climate, I would argue that that is an exhaustible natural resource. Now, then the measure has to relate to. So CBAM has to relate to the conservation of a stable climate. Well, yes, yeah, because again, or not again, but there you have a very soft relating to requirement, which means that there has to be a close and genuine relationship between CBAM and the conservation of a stable climate. And I think you can argue that there is. Yeah? And CBAM is not disproportionate to achieve that objective. There is, however, a query. This is something that also talking with my economist friends has come up. I didn't invent it. It's reflected in the literature too. But there is a question, how real is the danger of carbon leakage that CBAM seeks to address? We've been talking about carbon leakage, and none of you have made a comment, yes, but does it really happen? Does it really happen? And there's very little evidence, data on it, certainly on the European side. Why? Because we had these allowances, these free allowances, and these free allowances prevented CBAM from prevented carbon leakage from happening. So we're sort of assuming and reasoning that without these free allowances, there will be carbon leakage. And that's a pretty solid reasoning, at least for a non-economist. But nevertheless, the question is, how real is that danger? Will we really see European steel producers moving to countries with lower or no carbon pricing? Now, earlier in the course, colleague isn't there, I think, but earlier in the course, we did talk a bit about over the last years, decades, dirty industries moving to developing countries. That would already be an indication that carbon leakage is a real thing to fear. But okay, so this is because if there is no real danger of carbon leakage, of course, this genuine relationship would not be there. I'm just giving it to you something to reflect on. I think CBAM relates to the conservation of exhaustible natural resources. Also, given the fact that there's not much needed to come to the conclusion that a measure relates to. And then the other requirement in Article 20G is that the measure is taken in conjunction with restrictions on domestic production and consumption. And that is indeed the case, in the sense that there is a European emission trading system, but that's a system that currently works with free allowances for actually all the industries that use the products that fall under the CBAM scope of application. So what you will have to be careful for is that there is indeed, when you phase in CBAM, that you phase out free allowances. Because if the free allowances are not phased out, then you don't take restrictions on domestic production and consumption. Yeah. So, but CBAM provides for that phasing in, phasing out. Yeah. Does provide for it. So, 20G, yeah, that, well, so far, because now you would only have provisional justification. You then still have to go to the chapeau. But let's first, before we go to the chapeau, let's look at 20A, B, or D. And there, A, public models, B, the protection of the environment, D, to secure compliance with otherwise GATT consistent law or regulations. There you're hitting on the necessity comment. And as I played yesterday, necessity test, then we discussed it under Article 2.1 of the TBT agreement, but the necessity test here under Article 20 GATT is very similar. Not completely the same, but very similar. The first thing that you do is you weigh and balance three things. You weigh and balance, on the one hand, the importance of the objective pursuit. Yeah, the objective pursuit is reducing carbon emissions. I would say that in the context of fighting the climate crisis, this is a very important objective because the climate crisis is an existential threat to our existence. So, importance of the objective pursuit, very high. The contribution that CBAM will make to the reduction of carbon emissions. Well, currently, the scope is still quite limited. Which will help with the third factor, but still limited. And it imposes a carbon tax It doesn't prohibit these products. So what will the contribution be? Will CBAM, by imposing a tax on, for example, Indian imported steel, will that truly contribute to the reduction of carbon emission? Now, there you have to go back to the objectives of the measure. And one of the objectives of the measure was to address carbon leakage. And perhaps the European Union will have to be very careful as to how they define the objective pursuit. Because depending on that, the contribution of CBAM will be more or less. No, there will definitely be a contribution. But the contribution is how much? Very important objective. And how much of a contribution does CBAM make to that objective? And then finally, the trade restrictiveness of CBAM. Well, it's an additional import tax. Yeah? European Commission officials would not agree with that, but that's what it really is. It's not a ban of the product. It's not. So it is trade restrictive, but not killing trade. It's very unlikely that any panel will come to the conclusion that on the basis of this test, we already can make a definitive on the necessity. They may come to a provisional conclusion on necessity, and if they say, well, this is provisionally necessary, they will then go on and examine the existence of a reasonably available, less trade restrictive alternative measure equally achieving the objective pursuit. And it will be for the complainant to list the possible alternatives. And then for the European Union to say, oh, no, this is not realistically available. It may be difficult for the European Union to do that because they're a developed country, so most things in theory should be possible, but nevertheless. But what they probably less trade restrictive, they may argue that the alternative is not restrictive. That it does not achieve the same level of that it does not allow the objective to be achieved. And then I will only go slightly over time, and then we come to the chapeau. Come to the chapeau of Article 20. And some of you may already know, but if you look at the case law on Article 20, there are many measures that were actually provisionally justified, of which the panel and the appellate body said, oh yes, they are necessary to achieve the policy objective. But it was that the trouble really came under the chapeau. Think of the US shrimp case. The way in which the measure, that the provisionally justified measure, was applied. And it should not be applied in a way that constitutes arbitrary and unjustifiable discrimination. It's ... because there's a little bit more to this, but the rest is not, it's hardly case law in it, and not that important. Not applied in a manner constituted arbitrary or unjustifiable discrimination. There are currently two lines in the case law, and they exist next to each other. It's not that the latter, which comes second now, has replaced the first. First line of case law, in order to establish whether there was arbitrary or unjustifiable discrimination, is in the US shrimp case, what was started in the US shrimp case, appellate body reporting US shrimp, and has then been used again and again and again. And What does this case law tell us when we apply it to this case? There would be arbitrary discrimination. Or let's say to avoid finding that the measure was applied in a manner that constitutes arbitrary discrimination, you have to take into account, CBAM has to take into account the circumstances of and the efforts made to reduce carbon emissions by trading partners. Because you have to take into account the local circumstances and the efforts by the others in order to achieve the same objective. And then you have a problem, you have a big problem. The CBAM, whereas you can get CBAM discounts when you yourself have a carbon price mechanism in place, discuss that. CBAM does not give any credit for non-price policies to reduce carbon emissions. Now, the example at the moment, we discussed this, of a non-price policy to reduce carbon is the IRA and the tax credits that are given when you purchase an electrical vehicle. Subsidies are the general category of non-price policies to reduce carbon emissions. Subsidies are an example, but merely regulation. European Union says, CBAM says, no, we will only recognize carbon pricing. And this may be a problem under the chapeau. Since some of you are very interested in CDBR, and we'll talk a bit about that tomorrow. CDBR, the principle coming from the Paris Convention. All that may cause a problem here because CBAM does not fully address the problems that developing countries face on their carbon emissions. Secondly, under the US shrimp line of case law, I'm focusing on unjustified or unjustifiable discrimination. It is clear from US shrimp that before you resort to unilateral actions, as CBAM, you have to make a genuine effort to reach a multilateral solution to the problem. And the question here is whether there are sufficient efforts undertaken to negotiate a global carbon pricing mechanism. These negotiations are ongoing. I referred already in reply to a question to this, but are these negotiations, they don't need to lead to a result in order to be able to invoke or to pass the test under the chapeau, but there has to be a serious effort. See what that. So there should be a question mark here. Now, finally, the second line of case law on Article 20 is a more recent one. It's an approach to the chapeau that was set out in Brazil, retreaded tires. And if you apply that line of case law to this case, you would be asking, is the discrimination of carbon-intensive products explained by a rationale that bears a relationship with the legitimate objective of reducing carbon emissions? So the discrimination that you see happening has to have a rational relationship with the objective pursuit. And what may be the problem here, and as I said, I won't work this out, Professor Sharma will do that. It is provided that in certain circumstances, and these circumstances may be quite numerous, it's provided for the use of default values for carbon content in imported products. Default values. And as I said, they're not friendly. Yeah? And when the European Union would apply these default values, would you then still have carbon-intensive products with the discrimination of these carbon-intensive products whose carbon content has been determined in a default way, whether that's really still relationship to the legitimate objective of reducing carbon emissions. And here again, that's something that I already briefly mentioned before. We have a big problem. There does not exist currently a widely accepted methodology to determine carbon content. So, even if the measure is considered to be provisionally justified, and I think 20G is probably your better guess, even if it is provisionally justified, it may run into trouble under the chapeau. Will CBAM be challenged? And if so, by whom? It will be challenged. Yeah. By whom? By, hopefully, an MPIA party. Because if it's challenged by an MPIA party such as China, then the dispute settlement will lead to a legally binding conclusion. And as I've said a number of times already in public, it is at that time that the commitment of the European Union to a rules-based dispute settlement system will really be tested. What are they going to do if CBAM is found to be WTO inconsistent? I actually am expecting a challenge of, although now it's yet again sort of delayed by a year, but I'm also expecting a challenge of the deforestation-free products regulation, yeah, which I think you may even want to be more worried about than about CBAM. But it will be challenged. I don't see, and we could discuss for long, why has it not yet been challenged? There's a lot of politics, there's a lot of not quite knowing yet how it will affect, and yet the carbon taxes are not yet paid. Yeah? So the pain is not yet felt. All that may come in, explaining why it has not yet been challenged. Finally, the question that I will not answer for you, but I will let you to sleep over it. When I say that, it's not because it's one of the exam questions, but think about it. What do you think is a better instrument to address greenhouse gas emissions? Is it subsidies or is it carbon pricing? Now, for developing countries, I've already said this, for developing countries, the choice between the two is limited, yeah, because to subsidize is for many developing countries not really an option. So that means that requires you to put money on the table. Carbon pricing or any trade measure is more of an option. Now, I am saying a few things about the choice between the two. Subsidies, which under WTO law, be much more difficult to justify. Well, they could not be justified. The finding of inconsistency would be more likely. If you have carbon prices, any other measure that clearly falls only under the GATT, you at least can play with Article 20. The United States would also play with Article 21. Yeah.
Final comment. The European Union actually does both. Yeah. European Union has complies with pricing, but they bolster the list of subsidies to encourage lowering carbon emissions. The United States, at the federal level,
Does not have carbon pricing, but they do have carbon pricing at the state. California, for example, pricing. And with that, I'll leave it for today. Tomorrow, we're going to look at well, what does this all mean and how can we make progress?